Good morning to all of you. Welcome to Legal Matters by Sai Babu Sankara. Now we are going to discuss a case on the admission for Mbbs with the NCC reservation quota, NCC B certificate reservation quota. And of course, Supreme Court directed the authorities or the college management not to take any adverse or corrective steps till the matter is decided. Justice D.Y. Chandrachud and Madam Bela M. Trivedi, while deciding the case of Jigyasa Tiwari versus State of UP in special leave petition within brackets crime civil. So 9997 by 2022, right? They granted relief to a girl who is pursuing her third year Mbbs course in MLN College, Prayagraj, and directed the college not to take or not to cancel her seat on the ground that she did not actually possess the C certificate issued by the NCC authorities. So at the time of admission during the year 2019, this girl, Jigyasa Tiwari, she stated that she passed or she got the NCC B certificate. NCC B certificate, to whom they will issue, this is a matter of concern. Normally, people who have undergone the NCC course, definitely, we are the C, of course, I am not the C certificate holder, but I am the B certificate holder. I was given the B certificate in my degree. Final year C certificate, but I think my mother was not well. Actually, we are supposed to go to the camp in Ladakh or some area. Since her health was not good, I could not go. Anyway, I have to be satisfied with the B certificate. Attached to NCC attachment also. The army attachment was also taken place. We have gone to the army camp also. Of course, they are the olden, golden, forgotten days. But here, the main point is that this Tiwari, she stated that she got NCC B certificate. So at the time of enrollment, she has to produce the same. She could not produce the same. Of course, luckily, she is not in any reserved category. She doesn't belong to any. So reservation is 1% reservation. Is with the NCC. No doubt, they are given the seat. And she dodged or she could fail to produce the NCC certificate because the Director General of NCC clearly stated that NCC B certificate of particular category cannot be given to her because she did not study degree. If she studied degree, they would have awarded the NCC B. No doubt, she appeared for the examination. She was about to get it, but since she has not qualified, they did not give her the NCC B certificate. Of course, she was under the impression that the first grade degree NCC, actually NCC B, EE, EE, like that it will be there. She got only one certificate, but that is not a valid certificate. This is the main problem. They asked her to produce. Ultimately, she could not produce the required certificate by the actually as suggested by MLN College. Ultimately, now she has been prosecuting her studies. Now she has come to the third year. Now the management fixed a deadline to her, deadline or some date, and said that if he does not produce the so-called certificate, definitely they are going to cancel her seat. So this is the problem. Immediately she filed a writ petition before the Allahabad High Court, but Allahabad High Court said they dismissed her petition. Why? Because Allahabad High Court clearly said petitioner is maintaining inconsistent versions or inconsistent stand right from the inception of the petition. She says she has the NCC B certificate. She could not produce it, number one. Number two, she says that she has applied from unreserved category. So from unreserved category, she is definitely can get a seat. No doubt, definitely it is available. But the problem is when you promised to give the NCC certificate, you have to produce. Otherwise, definitely they are all the right way competent to cancel her seat because it is an administrative decision. Administrative decision of a college. High Court normally cannot interfere. So please remember, she says, please remember, the argument on behalf of her on 26/6/19 is that she had an NCC B certificate, but this did not make her eligible for the seat, and enrollment may be on the category of NCC, it may be removed, but even otherwise she is eligible for getting a seat. That is her version, right? So High Court said that she claims unreserved category. Just now I told you, she claims unreserved category, but court cannot include such qualifications in by judicial fiat. Yes, you do that, like the court cannot say. Please, that too. What is MBBS? In MBBS, merit is of paramount consideration. Merit is of paramount consideration unless you have got a merit. So that's why NEET examination, right? So Supreme Court also is of the same view. So not to take adverse steps, of course, till the matter is decided, because already she is in the midst of her study. So don't take coercion up. Of course, Supreme Court may decide. Of course, by the time the court decides, her course may also be completed. Anyway, for the present, she is given a relief that she cannot be removed from the seat. It's a good thing, right? So let us hope that she will continue her MBBS and pass over. What is the fun of removing her seat or cancelling her seat in third year? In my view, as an elder person, it may not be correct also. Of course, it's only a personal view. I should not imbibe the same on the authorities. Anyway, please remember, here the girl was lucky. Failure to produce the C certificate of NCC cannot be a ground for the cancellation of the MBBS admission as supposed by the Honorable Supreme Court of India. Please go through the judgment and you can enrich your legal knowledge. Thank you very much.